Dr. Harpreet Kaur from Army Institute of Law, Mohali. I'll be discussing with you the topic of concept of citizenship as per provisions of Indian Constitution. Introduction of the topic. Citizenship in Indian Constitution refers to the legal status of a person who is recognized as a member of the Indian state. A citizen of India has certain rights and privileges as well as certain duties and responsibilities as enshrined in the Indian Constitution. Part 2 of the Indian Constitution defines citizenship, which includes Article 5 to 11. According to Article 5, a person who was born in India or whose parents were born in India is considered to be a citizen of India. Additionally, a person may also acquire citizenship through registration or naturalization. The Citizenship Act of 1955 and its subsequent amendments provides the legal framework for citizenship in India. Citizens of India enjoy certain fundamental rights guaranteed by the Constitution, such as the right of freedom of speech and expression, the right to equality before law, and the right to practice any religion of their choice. They also have certain duties and responsibilities towards the states, such as paying taxes, respecting the Constitution and the law of the land, and upholding the sovereignty and integrity of India. Citizenship is a natural right that every country's citizen have. In a sovereign state, citizens of a nation have specific civil and political rights guaranteed by the Constitution. Citizenship refers to a person's relationship with the state to which they owe loyalty and is entitled to protection. Citizenship is listed in the Constitution's Union List and hence fall within the Parliament's sole control. In the Constitution, the term citizen is not defined. However, Part 2 explains the several categories of citizenship eligible, that is given under Article 5 to 11. Citizenship. The origin of citizenship can be traced back to ancient Greece, when citizens were those who had a legal right to participate in the affairs of the state. However, by no means was everyone a citizen. Slaves, peasants, women, or resident foreigners were made the subjects. For those who did have the privileged status of being citizens, the idea of civic virtue or being a good citizen was an important part of the concept, since participation was not considered only a right but also first of all a duty. Like any other modern democratic state, India also has two types of people, citizens and aliens. Citizens are the ones who are legitimate citizens of any state and enjoy all political and social rights, whereas aliens are those who, though residing in the territory of the state, do not enjoy the same privileges and rights as the citizens. However, there are two types of citizenship, single citizenship and dual citizenship. The former one implies that all the people in a country, irrespective of the state or territory they reside in, it implies uniform citizenship throughout the country, while the latter indicates that despite being a citizen of a country, one also has to acquire the citizenship of the state or the territory in which they reside. The USA, being a coming together federation, follow the system of dual citizenship, whereas India, being a union of states, follow the system of single citizenship. It ensures a sense of uniformity and a feeling of togetherness. Under the Indian Constitution, citizenship is dealt with under Chapter 2 extending from Article 5 to 11. Backdrop of Indian citizenship. After 3rd June 1947, when Lord Mountbatten announced his intention to scrap the Cabinet Mission Plan and introduced Indian Independence Act of 1947, it was decided that British India will be divided in two nations, that is India and Pakistan. A big question arose as to what will be our country's boundary, and as to who will be the citizen of India. It was because of one reason that a lot of people moved from Pakistan to India and India to Pakistan after the division of India. This question of citizenship has been dealt by our leaders during forming of the Constitution of India. They provided part 2 of the Constitution, which describes the eligibility of citizen of India on 26 January 1947. Whenever one discusses about population of a country or about people of India in our Constitution, the following terms are used. First is person, second is citizens, and third is minorities. These three terms in reference to people of India are used in our Constitution. First is person. All basic rights for equality are given to all persons under Article 14 of the Indian Constitution. Citizenship, but right against discrimination was given only to citizen of India in Article 15. It means right against Article 14 and 15 are given to only citizen of India, while right against Article 14 are given to all person of India who is residing here. Third is minorities. Some specific rights which are defined in Article 29 are given only to minorities in India, in addition of other rights given under Article 14 and 15. Citizen of a country is a full member of the state who owes allegiance to the state. A citizen has certain duties towards the state which he or she has to fulfill. Citizen of a country enjoys certain rights which are not enjoyed by aliens of a country. There are two types of aliens. First are friendly aliens and second are enemy aliens. Friendly aliens are those which have good relation with the country, and enemy aliens are those who have a bad relation with the country or who are at a war with the country. These people enjoy fewer rights than the friendly aliens. For example, in India, friendly aliens have a right of protection against arrest and detention, while enemy alien do not have this right. Concept of citizenship of India. The Indian citizenship can be seen as follows. Citizenship refers to the legal standing of a person as a sovereign country's legal member or a country member. Citizenship refers to the interaction between the individual and the state. Citizenship implies freedom with the obligation that accompany it. Citizens are full members of the Indian state and are bound by its laws. They are allowed to enjoy their civic and political rights without restriction. Citizenship is a concept of exclusion because non-citizens are excluded. Citizenship is granted according to two well-known principles. While the jus soli provides citizenship based on birthplace, the jus sanguinis recognizes blood ties. Since the Motilal Nehru Committee, the Indian leadership has backed the progressive concept of jus soli in year 1928. The Constituent Assembly also rejected the racial concept of jus sanguinis incompatible with the Indian ethos. Citizens of India have the following constitutional rights that aliens do not have. Some fundamental rights such as are exclusive to citizens. Article 15, 16, 19, 29 and Article 30 are exclusively available for Indians. Certain offices such as President, Vice President, Supreme Court or High Court Judge, Attorney General, Governor of a state and Advocate General are only open to citizens, and this is given under Article 165 of the Constitution. Citizens also have the right to vote in election to the House of the People of the Union and the Legislative Assembly of each state under Article 326, as well as the right to become a member of Parliament and the legislature of a state. All the above rights are denied to aliens whether they are friendly or hostile. However, enemy aliens have a special disadvantage. They are not entitled to the procedural provisions In Article 22 relating to arrest and detention, an alien enemy includes not only the subject of a state at war with India, but also Indian citizens who live in or trade with such a state of their own volition. The Constitution, on the other hand, did not intend to establish a permanent or a comprehensive law governing citizenship in India. Simply described the classes of people who would be deemed to be the statutory basis of citizens of India on the date of citizenship in the Constitution's commencement, and left the entire law of citizenship to be regulated by some future law made by the Parliament. Following the commencement of the Constitution, Parliament enacted the Citizenship Act, which made elaborate provisions for the acquisition and termination of citizenship. The provisions of this Act are to be read in conjunction with the provisions of Part 2 of the Constitution to obtain a complete picture of Indian citizenship law. Given that the Act of Parliament only addresses the modes of acquiring citizenship after the commencement of the Constitution, it would be more convenient to address them separately. Coming to the constitutional provisions governing citizenship. After the partition, it was seen that people were migrating from one border to another. Thus, it was difficult to frame the provisions for citizenship in India. Article 5, Citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India will be an Indian citizen if the person should have taken birth in the Indian territory, in case either of his parents has taken birth in the Indian territory. And third, if a person has been staying for more than 5 years in the territory of India. The apex court in the case of Satya versus Teja Singh, this judgment is of 1975 Supreme Court judgment, page number 105, held that to establish domicile, two elements must be proved. First is residence of a particular kind and second is intention of a particular kind. Domicile means the place which a person has fixed as a habitation of himself and his family, not for a mere special and temporary purpose, but with the present intention of making it his permanent house. In case of Muhammad Reza Debastani versus State of Bombay, 1996 judgment, Supreme Court at page number 1436, it was seen that the appellant's request for citizenship of India was rejected. The appellant had come to India with his uncle, and after several years of stay, he went to Iraq on pilgrimage. Then he was permitted to stay in India for years with repeated extension, but then he was denied and thus he pleaded. Then he returned to Iraq and got employed. This fact was enough to satisfy that he can't be granted citizenship of India according to the provisions made. Article 6 deals with citizenship of certain persons who have migrated from Pakistan. When a citizen of Pakistan has migrated to the territory of India, would be entitled to a right of citizenship under these conditions. First, if a person's parents or grandparents were born in India according to the Government of India Act 1935. Second, if a person has migrated and is ordinarily residing in India before 19th day of July 1948. In case of Kulathil Mamu versus State of Kerala, 1996 Supreme Court, page number 1614, the Supreme Court by majority held that word migrated in Article 6 and 7 was not used in that narrow sense of the term, but in a wider sense of going from one place to another, whether with an intention to reside permanently there or not, but the movement should be voluntary and should not be for a specific purpose and for a short or limited one. Coming to Article 7 deals with citizenship of certain migrant to Pakistan. If a person has migrated to the territories of Pakistan after 1st day of March 1947, he shall not be considered as a citizen of India. but there is an exception to it. A person who has migrated to the Pakistan territory and then returns back with the permission from the request authority. In the case of State of Bihar versus Kumar Amar Singh, AIR 1955, Supreme Court, page number 282, the wife left her husband and went to Karachi. According to her statement, she went to Karachi temporarily for treatment. Then she returned back to India and was permitted to stay, as she stated that she was Pakistan domiciled. Then after the expiry of the period, she returned back to Pakistan. Then she wanted to get the permanent citizenship of India when her property in India was to be taken under custody. It was held that as she had migrated before the date stated in the provision, she won't be given permanent citizenship. Next, coming to Article 8, citizenship of certain persons of India or region residing outside. If a person residing in a different country, but either of the parents or grandparents have taken birth in the Indian territory and if the person is registered as a citizen of India by the diplomatic or consular representative of India, shall be considered as a citizen of India. Article 9, persons voluntarily acquiring citizenship of a foreign state not to be a citizen. If a person has voluntarily adopted the citizenship of any foreign state, then we won't be considered as a citizen of India. In the case of state of UP versus Rahmatullah, AIR 1971, Supreme Court, page number 1382, it was held that the central government is authorized to take action against people who have acquired the foreign citizenship and have lost the citizenship of India, but they are still residing in the country. Now, Article 10 deals with continuance of right of citizenship. It says, when a person is considered as a citizen of India under the provisions provided, the person would continue to be a citizen if also new provisions are made by the Parliament. In the case of Ibrahim Wazir Mawat versus State of Bombay, judgment is of 1954, Supreme Court judgment, and is given on page 2 to 9. The constitutional validity of the Influx from Pakistan Control Act 1949 was put forward. The act provided that when a person has the domicile of either India or Pakistan, can't enter the premises of the above stated countries without permission. And if any person goes against the rule, then he would be convicted of the offence mentioned in the Act. According to Section 7, a person can be denied citizenship by central government under certain ground. It was held that removing a citizen from the country under Section 7 of the Constitution of India would amount to a deprivation of the right of citizenship as mentioned in Part 2 of the Constitution. Article 11 states the Parliament to regulate the right of the citizenship by law. It states that nothing can prohibit the Parliament's power to make any provision on termination or acquisition of citizenship and all other subjects related to citizenship. Now, I will be discussing with you the modes of acquiring of citizenship. First mode is citizenship by birth. According to Section 3 of the Citizenship Act, when a person is born on or after 26 January 1950, but before 1st July 1987, then he would be entitled to get citizenship by birth. When a person's parents are a citizen of India or either of the parents is a citizen of India, then a person would be entitled to get citizenship by birth. If one parent is a citizen of India and the other is not, then it is necessary to establish the fact that the other parent is not an illegal migrant at the time of the birth of the child. Next is citizenship by descent. According to Section 4, the Citizenship Act, a person born outside India on or after January 26, 1950 is a citizen of India by descent if his or her father was a citizen of India by birth. A person born outside India on or after December 10, 1992 But before December 3rd, 2004, if either of his or her parents was a citizen of India by birth. If a person born outside India or after December 3rd, 2004 has to acquire citizenship, his or her parents have to declare that the minor does not hold a passport of another country and his or her birth is registered at an Indian consulate within 1 year of the birth. But provided that a minor under this section is if a citizen of another country must renounce that within 6 months. Citizenship by registration. According to section 5 of the Citizenship Act, a person of Indian origin who has been a resident of India for 7 years before applying for registration, a person of Indian origin who is a resident of any country outside undivided India, a person who is married to an Indian citizen and is ordinarily resident of 7 years before applying for registration, minor children of persons who are citizenship of India. Citizenship by naturalization. According to section 6 of the Citizenship Act, when an application for grant of a certificate of naturalization is made by a person who is fully aged or has attained the capacity and the central government is satisfied that all conditions are fulfilled, then the person is granted the certificate of naturalization. When a person is granted the certificate of citizenship by naturalization, he has to take oath in the manner specified in the 3rd schedule. Next is citizenship by incorporation of territory. According to section 7 of the Citizenship Act, when any territory is added to the Constitution of India, then the people of those territories would be considered as the citizens of India. Those people would be granted citizenship by the official gazette once the central government notifies them. They would be considered as citizens from the date specified in the order. Overseas citizen of India, a foreign citizen of Indian origin, is given the permission of immigration to live and work in the Republic of India. This is known as Overseas Citizenship of India. It was introduced for the purpose of granting dual citizenship and it was brought into light from the Citizenship Amendment Act of 2005. People with overseas citizenship of India are permitted from certain rights: no right to vote, no right to hold constitutional offices, no right to buy agricultural properties. Next is dual citizenship. Availing dual citizenship of India and another country requires certain strict provisions. Earlier there was no provision of dual citizenship in India. These certain provisions are required to be fulfilled to obtain dual citizenship in India. When a person from another country is working in India and the child is born in India, then dual citizenship is granted to the child until the period of employment in India. A minor of Indian origin has the right to hold dual citizenship of India as well as another country. The minor is provided with dual citizenship so that the minor child chooses the preference of nationality before 6 months of attaining the age of 18. Now, advantages of dual citizenship. First is global mobilization. Only a few passports allow you to travel to any location, which can be very restrictive. This makes travel more difficult by necessitating the acquisition of travel visas. Obtaining a second passport can help to solve this problem by increasing mobility and eliminating bureaucratic systems. Second is businesses. Obtaining second citizen status opens the door to a plethora of opportunities and simplifies the completion of business transactions that would otherwise be unavailable or difficult to obtain following the issuance of an original passport. Next is security. Having a second passport that allows you to leave the country gives you peace of mind. You have a contingency plan in place in case of social, economic or political unrest in your own country. Next is quality. Depending on the passport you obtain, you may gain access to global healthcare and education as well as a better lifestyle overall. High net worth individual can maximize their potential simply by gaining access to greater opportunities in another country through dual citizenship. This includes planning for your future, whether it is through healthcare, education or a better way of life. Renunciation of Indian citizenship. Under Section 8 of the Citizenship Act 1995, the provision for renunciation of citizenship has been laid down. When both the parents are no more citizen of India, then their minor child is given the right to choose the nationality of his or her preference with the given period of time after he or she attains the age of 18. When a citizen of India has attained the age of maturity or capacity and decide to renunciate the citizenship of India, then he can submit his renunciation by registering under the prescribed authority. After submission to the prescribed authority, the person ceases to be a citizen of India. But if a person submits the request for renunciation of a citizenship during the period of war India is engaged in, then the request would be kept pending until directed by the central government of India. Next, I will be discussing the termination of Indian citizenship. According to Section 9 in the Citizenship Act of 1995, the following provisions are provided for the termination of citizenship. When a citizen of India voluntarily acquires the citizenship of another country, then he ceases to be a citizen of India. But a citizen of India who voluntarily acquires the citizenship of some other country during the period of war, then his citizenship won't be seized till the central government directs. There is a case law on this. In case of Bhagwati Prasad Dikshit versus Rajiv Gandhi, AIR 1986, Supreme Court, page number 1534, it was seen that the question raised was against the validity of election. According to the appellant, the respondent was to be disqualified from being a candidate in the election as he ceased to be a citizen of India. The respondent had challenged the verdict of the High Court. It was held that the High Court has correctly dismissed the plea because the arguments that were put forward did not disclose any cause of action. Moreover, the question of acquisition of foreign citizenship under Section 9 of the Citizenship Act is to be answered by the central government, and the High Court does not have the jurisdiction. Concluding this topic, that the concept of citizenship as per provisions of the Indian Constitution is comprehensive and multifaceted, reflecting the nation's commitment to inclusivity of rights and responsibilities. At its core, citizenship in India signifies the legal status of individuals recognized as members of Indian state. It is defined by birth, descent, registration or naturalization as outlined in the Constitution and elaborated upon in the Citizenship Act of 1955 and subsequent amendments. Indian citizens enjoy certain fundamental rights guaranteed by the Constitution, such as freedom of speech, equality before law, and the right to practice any religion. Alongside these rights, citizens also bear responsibilities towards the state, including paying of taxes, obeying the laws, and safeguarding the sovereignty and integrity of India. The Indian Constitution lays down clear provisions governing citizenship, encompassing various scenarios such as birth within Indian territory, descent from Indian citizens, migration and naturalization. These provisions are further supplemented by judicial interpretation and case law. Moreover, the Indian citizenship framework distinguishes between citizens and aliens, with citizens enjoying full membership in the state and certain privileges not available to aliens. Additionally, the concept of dual citizenship has been carefully considered with strict provisions governing its acquisition and renunciation. In essence, the concept of citizenship in India reflects a balance between rights and duties, inclusivity and national integrity. It is a dynamic aspect of constitutional governance, continually evolving to address the needs and complexities of a diverse and vibrant democracy like India. I hope you liked the lecture. Thank you and have a nice day.